Welcome back to Subject to Cross. This might be our first when we have like episode. It's Pete and Caroline.
It's
I'm
us.
a little less formal. This might
We're your hosts.
We could have like episode 45A and B.
Or just 45 and 46.
All right, whatever. So this is also some new legislation that was, I think, was is enacted at the same time. The effective date is June 11th of 2024.
Yes, it's part of the probation bill. Pete wanted to go into it in the last episode, but I stopped him so that we could all take a breather.
Yeah, and also, like, my attention span isn't more than 20 minutes. I don't expect that our listeners should be any longer than my own.
I think a 20-minute attention span attributable to you is really generous.
Yeah, it is. It is. I was maybe engaging in hyperbole. But in any event, clean slate law. So clean slate basically, I'll try to differentiate.
Are you going to make expungement sexy?
No, I can't do that. I made probation sexy, I hope, but the expungements are not sexy. Expungements basically mean that if you have a case, and sometimes convictions, but if you have a case and charges are withdrawn, for instance, or you go through a diversionary program and
charges are dismissed.
There's no conviction and the charges are dismissed. If you don't do anything,
or if you go to trial and you're acquitted,
if you don't do anything, then after that, you get to the finish line and you beat the case, then the record of those allegations is still going to be on your criminal history. In certain circumstances, charges are automatically expunged. I'm not going to talk about them. But in a lot of cases, if, for instance, you go to court, there's an allegation made against you, it's a big misunderstanding, they withdraw the charges, and you don't do anything, well, those charges are still going to appear if you were fingerprinted and photographed, which you are bound to have been fingerprinted and photographed in Pennsylvania. That's called processed. Those records go electronically to the Pennsylvania State Police in Harrisburg, and you have a criminal record. That criminal record may show, it should be updated and show that those charges were withdrawn or that you were acquitted. But what you want is for them not to be there at all. That's called an expungement, where your criminal history is wiped. And if somebody asks for your criminal history from the state police, they say, no record found. That's what you want, no record found. There are also other agencies, government agencies, that have criminal history information that can be expunged. For instance, the website that people have heard me harp on, because some of our criminal defense colleagues use that website to mass mail you letters when you are charged with a crime. People know I don't approve of that. But you're wiped from that website. The charges are removed from the website in the context of an expungement. What we're talking about today is record sealing. Record sealing, I would submit, Caroline, is in just about all important respects the same thing as an expungement. Fight me.
Oh, I'm not really interested in fighting you.
Yeah, so because you don't find this sexy at all.
Well, I think it's important, and it's important to you.
No, I think it's important to our potential clients. It's not necessarily important to me.
Look, you can seal your record, you can expunge your record, but what's really nice is now oftentimes you don't need to do anything to have your record sealed. And that's the law from 2018, and it's been expanded recently, and that's what Pete wants to talk about. And it's important, actually, in action, when you have somebody who otherwise lives a law-abiding life, a responsible life, but they have this record that keeps them from doing things that are important to their life, and it could be a really old record as well. It's just not necessary to keep, and it's not, let me clarify, those offenses might not be eligible for expungement, which is the total destruction of any record of it. This is clean slate. This just cleans up your record artificially so other people can't see it, so that you can get where you need to go in life.
Yeah, and the difference is clean slate, record sealing, we're using those terms interchangeably. We're talking about the same thing. There's clean slate limited access is the one thing they call it, and then the other one is, I think, clean slate automatic or something like that, but it's record sealing. The record sealing, what that means is the public can't access it. Law enforcement still can. So it's not completely removed. The cops and prosecutors can see it, but employers, housing, people that otherwise could use criminal convictions against you to affect your daily life cannot.
Right. It cannot be used for, the law clarifies that once the record's been sealed, it cannot be used for employment, housing, educational purposes. It also can't be used for occupational licenses.
And just so you think Caroline didn't have all that stuff memorized, she's reading, I like to attribute articles, Sunday Inquirer, February 18th. This is called New Law Helps Seal Felony Records. And it does start with the story of a guy who was 61 years old. He's working on high rises in Atlantic City, risking his life, I guess, and couldn't. Not that there's anything wrong with working on a high rise in Atlantic City, but he's talking about the cold coming off the water and guys snot freezing in their mustache. I had to get that
Well, you're just getting very
that's
theatrical over there.
It's getting in here.
It's kind of.
But he has a college degree. Was once just 9 credits away from a master's degree in education. Had an idea of what he wanted to do with that and couldn't because of a youthful indiscretion where he went through a bad split. I don't know how young he was, but it was from a while ago. He's 61 now. And he was in a bad way. He admits he was in a bad way. He got into drugs and ended up with a criminal conviction. His only option was construction. He was, I think, one of the first, they say he was one of the first Philadelphians to benefit from the state's newly expanded clean slate law, which allows people with certain felony convictions to have their criminal records sealed by filing court petitions. That's a petition for limited access. So what this Clean Slate 3.0 is what they're calling it, does is it expands to felonies. And as best I can tell, qualifying felonies, that's what the term is, are felony 3 offenses or ungraded felony drug offenses.
So like possession with intent to deliver.
If it's an ungraded felony drug offense, yes, along with theft charges, trespass, welfare fraud, which I convicted you of the last episode.
And I got a year and a half of probation ultimately. Thank you.
You're welcome. Forgery, they're eligible for expungement. And it goes, and that's called a petition for limited access. And so that one you do have to petition for. That's not automatic. That's where you would hire somebody like us, and we would file a petition for limited access on a felony conviction. And they've also reduced the 10-year waiting period to a 7-year waiting period. What that means is that you have to be out of trouble for 7 years. As long as you're out of trouble for 7 years.
For felonies?
Yeah. You can expunge felonies.
No,
and
seal.
Seal. Sorry. Oh, no, I misspoke. I'm sorry. It's 7 years for an M1 and below.
Okay.
It's 10 years for a qualifying felony. I apologize.
And is it automatic for an M1?
Well, that's like some of the stuff. So the clean slate limited access, M2 and M3s, it happens automatically at 7 years. And for qualifying drug offenses, or qualifying offense, not a qualifying drug offense, it's 10 years. Some of this stuff becomes pretty confusing, frankly, but as best I can tell, things that don't happen automatically would be a qualifying felony. Well, and that's where you would need to hire a lawyer to file a petition for limited access under 9122.1 versus this automatic expungement, which is 9122.2.
And also where it gets a little confusing but fun for us lawyers is when we get a client that wants their record cleaned up, and the record is riddled with so many different things. It could be a juvenile adjudication. It could be a few summary offenses that are eligible for expungement. That doesn't mean they automatically happen. You have to file petitions. There could be some clean slate action that'll automatically happen, but also there could be some clean slate action that needs to be petitioned. And it just is like a mishmash of petitioning that we need to do and likely advocacy we have to do in court before a judge.
Yeah, and I'm reading my notes, which of course are completely illegible.
Read that.
These are actually not bad. It looks to me like for a qualifying felony offense, theft, trespass, welfare fraud, forgery, those are either felony 3s or ungraded felonies. It excludes F1 and F2s, by the way, felony first and felony second degrees. You would have to file a petition. The clean slate limited access, M2 and M3 offenses automatically are going to be removed after 7 years. That used to be 10, I think. And then qualifying offense, is drugs, basically. Drugs only, not the other felonies, but drug felonies are 10 years automatic anyway. So there's a little overlap there. Like, I don't know why you would necessarily. Well, I guess you could petition early at 7 years to get rid of the felony drug stuff as opposed to waiting 10 years when it happens automatically. But I think what we're seeing here, importantly, is an expansion of the ability to clean people's records. It's only going to, I think, grow from here.
It's an extension of getting people off the hamster wheel
Exactly.
of the criminal justice system.
We're just,
Bravo, Mr. Shapiro.
The hamster wheel.
Or the rat wheel.
I prefer the rat wheel. But I think this is all really good stuff because there's no sense in people carrying a scarlet letter 10, 15 years later that prevents them from being a productive member of society and prevents rehabilitation. We're all about rehabilitation, right? So I think this is good. I think it's only going to expand from here, frankly. And just like when we were talking about the probation reform stuff, I hope that expands into the sentencing generally, and I hope it expands into parole. Why wouldn't, like, if you're on parole for a long time, apply some of those standards to a parole violation? You're 15, I have clients that have violated parole after they've been law-abiding for, 2 years, let's say, and they're within like the last, month of parole and they violate. It should be factored in the amount of time that they were law-abiding. I just think it's common sense stuff, and I think it takes a long time for lawyers to exercise common sense.
Well, that's a great note to end on.
Did I make record sealing interesting?
I think it was fine. Yes.
Okay.
Yeah.
Right.
I think that worked out.
Yeah.
Anything else you want to add to it?
No. Other than you can contact us
at subjectacross@mcelroy.com. Also, one thing, I just don't want to mislead anybody. When we're saying these laws give a mechanism to, get off of probation earlier, to clean up a record early, or to seal a record early, it doesn't mean the DA's office won't object. It doesn't mean that it's going to be always easy, but it's
true.
A tool that's out there, and we want you to know.
That's a very good caveat.
Thank you. All right. Email us at subjectacross@mcelroy.com. Talk to you soon. Bye-bye.
Oh, bye.